welcome everyone. As Lisa said, I'm Monique Botkin, Associate General Counsel at the Investment Advisor Association. We're delighted that you're joining us today to discuss the SEC's new private fund advisor rules that were adopted last August. The first compliance date for larger private fund advisors is just 7 months away, so the rulemaking remains top of mind for everyone. I'm joined today by our expert panel of partners from Kirkland & Ellis, Alpa Patel and Melissa Gaynor, who are based in Washington, D.C., and Josh Westerholm and Nick Hemmingson, who are based in Chicago. By way of background on this rulemaking, in 2022, the IAA submitted a detailed comment letter on the proposal on behalf of members, and with the tremendous assistance of Kirkland, we urged the SEC to move away from the proposed prohibitions towards a disclosure-based approach more in line with the Advisors Act principles-based fiduciary framework. While we are pleased that some of the recommendations the IAA made were included in the final rules, many challenges remain with the way in which the rules apply to advisors and impact their relationships with private fund clients and fund LPs. We'll focus today on the main components of the rules and some key takeaways for implementation as you consider the impact on your funds and other investment products, as well as on your affiliates and business partners. Lastly, as you know, there is pending litigation seeking to vacate the rules, and we'll also address the status of the litigation. I look forward to the discussion, and I will now turn it over to Alpa Patel to get us started. Alpa?
All right, thanks, Monique, and thanks everyone for joining us. Welcome, and hopefully we can cover all the issues that you've been thinking about through the deck here, as well as through the chat channel. We're happy to make this as useful as possible. I want to thank the IAA for inviting us to speak with you today, but also for their leadership on this issue. As you can tell with Monique's sort of preface there, the rules have changed a lot from the proposal to the adopting release, and groups like the IAA, who spent a lot of time writing really thoughtful comment letters and organizing members to go in to speak with the SEC, certainly had an effect to temper the rules as they were originally proposed. But obviously, there are still issues to work through. And I'm joined by my wonderful panelists here. I'm grateful to work at Kirkland & Ellis, where I've got three wonderful partners, Nick, Melissa, and Josh, who along with the other 50 regulatory partners here at Kirkland, have spent many hours thinking through this rule, whether it's just what does the rule say on the words on the page, but also talking to a variety of clients over the last few months about what it means to their business and helping us articulate what's the best way to think about this across the client base, whether you're a large advisor or small, or have just closed-end funds or open-end funds. So hopefully we're able to sort of distill down some of those nuggets of expertise for this group. But again, please feel free to send in questions as they come up, and we can move to the next slide. On slide 3 here, as you guys know, the rule is sort of broken out. There's 6 different rules here, and we'll go through each of them with varying levels of detail based on what we think are sort of the heavier lifts. Josh will talk through the scoping mechanism, and then we'll start, Melissa, on the quarterly statements, mainly because that's the biggest, even though that has a later compliance date, that's sort of the biggest lift, as we've discovered with many of our clients. And on the next page, we'll just give you an idea of where we've been. August 22, 2023 is when the SEC issued these rules. It's been a beast, even in the proposal to adopting stage. It's been the most intensive SEC rule governing private funds since advisors had to register back in 2012. So we've certainly spent a lot of time thinking through how it'll apply, but most importantly, how advisors of all sizes will implement the rule. As Monique mentioned on slide 5 here, we can get to just the discussion of the private fund industry group's lawsuit that was filed pretty quickly after the rules came out. Within 2 weeks, a variety of groups filed suit strategically in the Fifth Circuit, and oral arguments just occurred, actually just last week. So quite the Super Bowl for your regulatory lawyers here, and trying to pay attention to read the tea leaves. Always hard to tell. The Fifth Circuit is notoriously hostile to federal government just in general, and the panel was equally questioning of the SEC's authority, but it will be difficult to gauge where they will land ultimately. While the petitioners and the SEC have agreed to sort of work through an expedited schedule of briefing, we're hopeful the Fifth Circuit will issue an opinion by the end of May, but there's really no guarantee that they will follow through with that timeline, where that's more of us requesting that timeline, and this may very well leak into the summer, which, as we'll talk about in a minute on compliance dates, that leads to a real implementation issue if you're sitting in your shoes as an advisor. How do I gauge the level of information, the level of work I need to put into complying with these rules that most important of these, the heavier ones of these will start in September, but these rules could be vacated, and I don't want to cry wolf with the business people. So we'll talk a little bit about, where you should be right now. I think it is worth having these conversations while there's hope that the Fifth Circuit will come through and strike down some of the rules. It's quite possible it's some and not all, or vacate some but not all, and nobody can tell you where that's going to land. I think that we are in the position of telling clients we should just keep on trucking on, and that's how we've spent our lives in the last 6 months, in hoping for the best but preparing for the worst. If we can go to the next slide, we'll talk a little bit about the compliance dates, which is why we're gathered here today, basically. And while we'll hope that the rules go away come early summertime, there is a chance they are not. And you'll see here the quarterly statements that we'll jump into in a second are the most burdensome. They actually have the longest compliance date. So keep that in mind as we talk through this. The compliance date here is March 14th, 2025, which means basically your first report will be due for the first quarter of 2025, 45 days after that. But as you go down a little bit further, what Nick and I will talk through is the restricted activities and the preferential treatment rules. Those come into play this year, September 2024. So certainly something we are working through with clients, how to think about that, because if you're fundraising right now, those are active discussions that need to be sort of raised to the business level, and the IR folks make sure they understand as they're negotiating side letters, these are provisions that are going to have an effect on funds if these rules stay intact in September. So with that, I'll turn it over to Josh to talk through sort of just a basic scoping exercise to think about what's in and what's out.
Thanks a lot for that, Alpa. And let me first add my thanks and appreciation for everyone who's joined, and for IAA for putting another great event together. Scope of the rules, really the rules are designed to pick up every advisor broadly to private funds, and we'll talk through what that means. Although the rules vary depending on whether you're SEC registered or exempt, like an exempt reporting advisor, a venture capital advisor, or mid-sized private fund advisor, they get fewer rules. Our anticipation, based on the folks that we see in attendance, that most of you will be SEC registered, and so we'll aim our comments largely at folks that are. There's a carve out for firms that are non-US domiciled, so based outside the US if they are advising non-US domiciled funds. So a London-based sponsor advising a Cayman-based fund or a Jersey-based fund, for example, will be out of the rules. However, right back into the fray, out of the fire, back into the frying pan, perhaps, or folks that have a US domiciled affiliate. And many of you, even if you have non-US advisory entities or management companies, will have a US domiciled sub-advisor entity that will have the effect of pulling you right back into the regime. I'm not the only one in this session that's had a client reach out and say, hey, could we just fire everyone from the US and fold up the operations there in hopes of avoiding the rules? So far, thankfully, no one has gone that far. I think that was a very justifiable, although knee-jerk reaction to seeing the rules get adopted. As a matter of scope, we're only talking about investment advisors, not folks that are sort of outside the definition, like a family office would be. Ticking over to the next slide, these are rules for covered funds, private funds, meaning funds that are exempt under the Company Act, 3C1, which is fewer than 100 beneficial owners, or 3C7, qualified purchaser owners only. If you advise 3C1s or 3C7s, you're in. And what that means is that the SEC is very focused on private funds that are structured in this manner, and not focused on pooled investment vehicles with a lot of the same characteristics that just rely on a different Company Act exemption. And that's a quirk of the way they currently view the world, that private funds leaning on 3C1 or 3C7 is where the risks and conflicts lie. But if you advise, for example, a real estate fund exempt under 3C5, other vehicles that are outside of the investment company definition, like under the 40% investment securities test in Company Act Section 3A, these rules don't apply in those contexts. And so there will be some relief for those of you that have multiple lines, and in particular, some real estate funds which have a worse treatment under the marketing rule in that they have to disclose more performance data, but a better treatment under these rules in that they aren't picked up in the same way. Securitized asset funds are also out, just sort of by rule. The SEC doesn't see the same risks and conflicts operating in that space as they do in other private funds. Ticking over to slide 9, we have laid out for you in a summary chart just which rules apply depending on domicile, depending on registered or non-registered. It's nice to be an exempt family office. If anyone is joined, you could probably go and get an afternoon coffee if desired, because it's all no's in that column. But you can see for U.S. domiciled, the left 2 columns there, really substantially picked up by what we're going to be discussing in the coming minutes. And with that, I'll turn it over for the first of our substantive sections on the next slide.
Thanks, Josh. I'm going to do a quick walkthrough of the quarterly statement rule. I think this, as Alba mentioned, will be the rule that many advisors end up spending the greatest amount of their time on, both in connection with the initial implementation, but on an ongoing basis, since this quarterly reporting will be due every single quarter. So what does the rule require? The rule requires an SEC registered investment advisor to prepare and deliver quarterly statements to LPs within 45 days after the end of the private fund's first 3 fiscal quarters and 90 days after the end of the fiscal year. And that's 75 and 120 days for fund of funds. As Alba mentioned, we think that absent SEC guidance, the first quarterly statement will cover first quarter 2025. So that means May 15th, 2025. You can mark that date on your calendar. June 14th, 2025 for a fund of fund. This will primarily impact SEC registered primary advisors to the fund, though if you are a sub-advisor, and let's say the primary advisor is a non-US advisor that is not registered, you will have the obligation to deliver a quarterly statement if it is not already being delivered. And in that case, it likely would not. Importantly, I think one thing I want to mention is that there's language in the rule that says that that gives some flexibility in scenarios where sorry, I got ahead of myself. We're covering that on the next slide. But what I did want to say here is that you'll notice that for the fourth quarter of the year, the date that the quarterly statement is due is different than the date that your audited financial statements are due under the custody rule. They're due at 90 days for purposes of this rule, 120 days for the custody rule. So there could be scenarios where your audited financials are not yet ready. One practice point we're recommending on this is if they're not ready, to include a footnote explaining these are non-audited numbers, and that the audited financials will be coming shortly. And that is something that I think is important, particularly if those numbers change. You'll have a little bit of coverage to note that they were subject to change because they were not audited. Turning to the next slide, this goes into a little bit of the information that will be required in connection with the quarterly statement report. Next slide, please. Sorry. One interesting aspect of this rule is that it says similar pools of assets should be consolidated to the extent doing so provides more meaningful information to investors and is not misleading. The definition of similar pool of assets is the same definition that you will see talked about later in connection with a preferential treatment rule, but I think it is considered to be a more narrow term in connection with a quarterly statement rule. The examples given in the release themselves are very narrow. It talks about most likely a similar pool of assets that would meet this test to be a master feeder or a parallel fund structure. So noting that that is one initial step that you should consider, whether you do have similar pools of assets that you would consider consolidating for purposes of the quarterly statement report. The quarterly statement can be posted to a data site. It does not need to be mailed or sent via email, but you do need to keep records indicating that you posted it, as well as hopefully information indicating that you notified investors that it was available in the data site. This is the provision that I was thinking about on the prior slide, which is that there is some language in the release and the rule that indicates that there is some ability, there is some excuse if you are unable to meet those short timelines we talked about on the prior slide. But that delay needs to be unforeseen circumstances. The advisor reasonably believed that they'd be able to deliver by the deadline, and the advisor delivers the statements as promptly as practicable. We think this will be very narrowly interpreted. It's similar to the language that the SEC has in an FAQ on the custody rule for when audited financials are excused from the 120-day date. And so this is not something you can rely on quarter after quarter to get comfortable that you've met your requirements. This is really just a once in a while when everything goes wrong that will give you a little bit of comfort. Turning to the next slide, this really starts to go into what must be included within the quarterly statement itself. At first, there is a table that needs to explain expenses that were paid by the fund, and that has two buckets of expenses. The first is all compensation paid or allocated to the advisor or its related persons from the private fund, and the second is all other expenses paid by the fund. The first bucket, which is the compensation paid to the advisor or its related persons, isn't limited to advisory fees or management fees. It's really any sorts of compensation that you are paying to the advisor or its related persons, depending on the facts and circumstances. You also are required to disclose the amounts of any offsets, rebates, or waivers carried forward from subsequent periods. In addition to the fund level expenses, the quarterly statement also needs to provide information about amounts the portfolio investment of a private fund paid the advisor or its related persons. This is not every expense that a portfolio investment pays. It really is limited to those that are paid to the advisor or its related persons. This information has to be provided on a portfolio investment by portfolio investment basis. So you need to break up the different investments and the amounts that were paid. The advisor doesn't have to disclose the name of the portfolio investment that is making the compensation. You can use codes, unless doing so would hide effectively a conflict or some information that would be relevant to the LP. For example, if there was a scenario where it was a wholly owned portfolio company, perhaps, and there were some conflicts with the services that they were paying the advisor or related person for, in that case, you might want to consider either disclosing the name of the portfolio company or providing some disclosure around the types of services and the relationship between the advisor and the portfolio company. In addition, this part of the portfolio, this part of the quarterly statement requirement also requires an advisor to disclose how they calculated all of the amounts, both at the fund table as well as the portfolio company table, as well as why they can charge it with cross-references to the applicable parts of the governing documents. In addition, sorry, a few slides, 2 slides ahead, please. In addition to information about the expenses that are being paid, an advisor is also going to have to provide certain performance information. Performance information that has to be provided differs depending on whether the fund at issue is a liquid fund or an illiquid fund. An illiquid fund is defined as a fund that's not required to redeem interests at the investor's request and has limited opportunities, if any, to withdraw before termination of the fund. In general, ability to redeem or being forced to redeem because of regulatory reasons, we don't consider something moving a fund into the liquid category. Those are sort of outside the scope. And liquid fund is defined as anything that is not an illiquid fund. So the information, the performance information that has to be provided for in a liquid fund is gross and net IRR and MOIC for the full fund portfolio since the fund's inceptions, both with and without the use of fund level subscription facilities. something we've been talking a lot about the last week since the new marketing rule FAQ looks a lot like this new requirement, and perhaps is based in part on this new requirement and language in the adopting release, questioning whether an IRR that reflects a subline is misleading. I think that might have been in the back of the mind of staff as they were interpreting the marketing rule. Unlike a recent marketing rule FAQ, gross IRR and MOIC for both the realized and unrealized portions of the fund portfolio, these two different extracts, only have to be shown on a gross basis, though they do have to be shown both with and without the use of the fund level subline. In addition to this performance information for liquid funds, a full statement of aggregate contributions and distributions since the fund's inception, including the value and date of each inflow and outflow. The release implies that's to have give LPs the ability to check your math, as well as a statement of the fund's net asset value as of the end of the relevant reporting period is required. The next slide goes into the performance information that is required for a liquid fund. And it's what you would expect for a liquid fund: net total returns on an annual basis for each fiscal year during the 10 years prior to the quarterly statement or since inception, whichever is shorter, 1, 5, and 10-year returns as well. And on a cumulative basis, the net total return for the current fiscal year as of the end of the most recent quarter covered by the quarterly statement. The quarterly statement rule actually defines MOIC and IRR, but it doesn't define net total return. It indicates that an advisor has some degree of flexibility based on industry practices and norms to figure out how they're going to calculate the net total return. That being said, it will be important for you to disclose exactly how you're calculating the net total return in a footnote to this part of the quarterly statement. So if we turn to the next slide, this goes into a lot more information that we think you also need to disclose. I don't think anybody thinks the quarterly report is going to fit on a page or a few pages. I think it will be a big document and get bigger depending on the vintage of the fund based on the inflow and outflow information that has to be provided each quarter. The quarterly statement, you're going to disclose all your criteria, assumptions, and manner in which expensive payments, allocations, rebates, waivers, offsets, and performance information are calculated, description of the structure and method used to determine performance-based comp, criteria on which each type of comp is based, for illiquid funds, fee rate for calculating net performance metrics, methodology used to determine whether an investment is realized or unrealized. For liquid funds, whether dividends or other distributions are reinvested, as well as your calculation methodology in and of itself. And so what are some key takeaways for the quarterly statement rule? I think if this discussion, if you take nothing else away from this description of the quarterly statement rule, it's that there's a lot, and there are a lot of teams that are likely involved to be able to produce a quarterly statement, particularly on the timeframes that will ultimately be required. And so right now, what we're recommending folks do is really think about steps that they can take to prepare themselves to start getting ready for this particular element of the private fund advisor rules. Again, this is not, this is at the end, this is sort of the last piece of compliance, but it is the biggest piece of compliance. And so putting in place good processes now that are repeatable are important, because one element that is discussed in the release is that the commission does expect the quarterly statements to look the same quarter after quarter to allow for comparability. So it will be important to have a good sense of where you want to start. I think, you know, there will be lessons learned and there will be some ability to change and move, but I do think having a good process at the outset is particularly important for this rule, given that requirement. And so this really is some of our suggestions. To the extent that you're getting expense reports now that are at a very high level, consider more detail. Other or miscellaneous will not be acceptable categories on the quarterly statement, so they can't be acceptable categories on expense reporting. Also thinking about you know, who needs to prepare templates, who needs to be involved, getting technology involved early will also be helpful. And keeping good records of all the decisions you're making along the way, I think is something you'll hear from each of us during the course of this presentation. For example, you need to decide whether you're treating a particular fund as a liquid fund or an illiquid fund. There could be some funds where that's a close determination, and you need to keep records explaining what your decision. So with that, I think that is the quarterly statement rule in a nutshell. There will be many more discussions that we will have about the quarterly statement rule, I am sure.
And Melissa, I guess one thing I would just highlight, it's worth folks talking to their administrators to see, are they capable of helping here? I've heard differing accounts. Some are sort of committing to being able to, maybe not right now, but you know, they'll re-engage if they're working on a template. Others have been less committal, and we know groups like ILPA and the like are certainly trying to come up with a template on their own and with some industry engagement, and TBD what that looks like, because obviously given the limited partner bent of the group, it's going to be much more granular than maybe is necessary. So this is sort of trying to figure out, maybe instead of spending a ton of time yourselves coming up with a template, just talking to service providers and others to figure out if there's one available soon enough.
Yeah, and I think, one thing I'd add to that Alba is, a template unfortunately won't be the end of the story for most folks, because this is a little bit facts and circumstances, particularly on the portfolio comp piece. You could have bespoke facts, and that's, I think, where the need for disclosure will be greatest in some respects. And so I totally agree. A template from an administrator or other group that is putting something out would be a great place to start. And so I think a lot of what you can be doing is less thinking about the template than what's going to feed into template today, right? Like those expense reports, those sorts of processes that you have in place is probably where I would focus my resources right now.
And 45 days is hard. That seems to be the biggest issue. I think all of us, as we've spoken to clients, is, yeah, we probably have all this information. It's going to be annoying, but I can probably get it. And I know where to get it from, but that 45-day time period seems to be the hardest piece. That's going to require, sort of changing around the priorities at the end of the quarter.
And I'd say that's particularly for funds that have non-controlled portfolio companies too. Thinking about what sort of diligence process you're going to put in place to be comfortable that you're disclosing all of the portfolio company compensation that you have, maybe with imperfect information in a short period of time. I think that's going to be a challenge. There is some helpful language in the adopting release that says in those scenarios where you can't get the information, it will be you can demonstrate that you undertook a diligence process to try to report appropriately. But again, that is going to be a process to show, in the absence of accurate, good information, what steps you took to provide the most transparent report you could to your LPs.
Great, that's really helpful. I just wanted to mention the first CLE code word, and that is investment. Investment. Moving on.
Good. Okay. Yeah, thanks, Monique. Thanks, Melissa. So moving on to the preferential treatment rules, of this aspect of the broader private fund rulemaking package. So I'll start with the compliance data. I know kind of Josh covered this earlier, but this is one of those I think Apple covered this. This is one of those that's part of the earlier compliance date package for large managers. So if you're over $1.5 billion, your compliance date for this aspect of the rule will be September 14, 2024. If you are under $1.5 billion, Joy's doing this in my office, a phone rings in the middle of it. If you're under $1.5 billion, your compliance date will be March 14, 2025. So this one I think is important. I don't want to say it's more important than the other ones or more burdensome than some of the other rules that we're going to cover, or just saying that because I'm covering this piece. But I do think this is an important rule that's getting a lot of attention, because I think there are some aspects of the rule, including quarterly statements, which, as Melissa noted, is going to be extremely burdensome from an administrative and compliance perspective. Kind of get the house in order, get that information categorized in the right manner and the right template and distributed on a quarterly basis. But some of the aspects of the preferential treatment rule will, I think, have an impact on your commercial agreements and your negotiating posture with limited partners. So I think there's a true kind of commercial impact from this aspect of the rule that's not just purely, compliance or administrative burdens on a firm. So getting into the teeth of the rule, there's two prongs here. There's the prohibitions under the rule, and then there's the disclosure under the rule. And we'll kind of take each of those in turn, starting with the prohibitions under the rule. And I'll note that the prohibitions were granted legacy status, and the disclosure requirements were not granted legacy status. And we'll kind of talk about what that means as we go through these over the next few slides. So first, the prohibitions. There are two of these. One is a redemption rights prohibition. So I think that's actually on the prior slide. Sorry. So that the one is the redemption rights prohibition. The other is an information rights prohibition. So first, the redemption rights prohibition basically says that you can't provide, an advisor just is prohibited from providing preferential redemption rights to investors in a private fund unless you fit within two exceptions. One is the redemptions are required pursuant to applicable law. So if there is actually a state law, for example, that requires a state plan that's, or, a plan that's governed by that state law, to have a redemption right that's different from others in the private fund, that would be accepted from the rule. This, however, does not cover, policy plans or policy rules that say we need to go and when we negotiate a side letter, get redemption rights, only if those rights are actually required by law in the applicable jurisdiction or the applicable governing body over that plan or investor. The other one is if the advisor offers the redemption rights to everyone, and that's an offer to everybody without exception to size. So this can't be, we offered it to everybody that was in the 100 million investor and over bucket, like we would under, traditional MFN arrangement. It means everybody in the private fund gets offered the same investment or redemption. One thing I kind of glossed over in that first bullet point that we'll talk about in the next few slides is this relates to redemption rights. I guess there's two other aspects of this that we should highlight. One is redemption rights have to have a material negative effect. That's a determination the sponsor has to make. And it would have to have a material negative effect on investors in that fund where you granted the redemption right to another investor or a similar pool of assets. So we'll talk about the importance of those and what those mean in the next slides. But keep that in mind that that's a big aspect of the redemption rights prohibition and the information rights prohibition. Next slide, please. So the information rights prohibition, similar to preferential, the preferential restriction on preferential redemption rights, is this prohibits advisors from providing preferential treatments rights with respect to enhanced information related to portfolio holdings or exposure. And again, that the advisor expects will have a material negative effect on other investors in that fund or a similar pool of assets. I think the similar pool of assets here is probably more of a nuanced consideration in the information rights aspect than the redemption rights aspects. I think it's a little bit easier to determine there. And we'll talk about that in the next slide. There is no required by law exception for this one. The only exception is you can provide enhanced information rights if you give it to everyone in that fund or in a similar pool sense. The SEC did not, helpfully or unhelpfully, they kind of left the question open of what particular information would be considered preferential information, other than to state that not everything will have a material negative effect in the context of information rights. So there may be certain information rights that are granted to investors that don't meet this category or that we can determine don't have a material negative effect, but there's no kind of guardrails or parameters that the SEC in the adopting release or with respect to these rules has laid out for us. And again, importantly, with respect to both prohibitions, these were granted legacy status. So that means if you granted preferential information rights or preferential redemption rights prior to the compliance date, then you're good with respect to this. You have to go back and reopen those contracts or reopen those side letters and say, yeah, we have to give this, we're not giving this to you anymore. Those are kind of locked in because they were granted before the compliance date, even if they would have a material. Okay, and then on the next slide, the following two slides will cover material negative effect and substantial similar pool of assets. So what's a material negative effect? Again, in order for a preferential redemption right or a preferential information right to be prohibited, you have to determine, the sponsor has to determine that it has a material negative effect on other investors in that private fund or in a similar pool of assets. The SEC did, I think helpfully note for us, although I think it's prompted a lot of questions on how far this goes. Is this some sort of a blanket exception for sponsors of closed-end funds without liquidity opportunities for investors to just grant information rights freely? I think that's one end of the spectrum of views. You know, the other end is they meant this to be incredibly broad, and every information right will have a material negative effect. But the SEC did helpfully say that the ability to redeem is an important thing in determining whether or not providing information rights would have a material negative effect on other investors. And the reason they said that, and the reason we think that is an important aspect, is if you're providing preferential information rights, what is the harm or potential harm to other investors? You provide preferential information rights regarding the portfolio, regarding how certain companies are doing, regarding how the portfolio is doing as a whole, or the exposure that the portfolio has to different, sectors of the market, and they get that information before another investor, and the fund gets that information, or before another investor in a similar pool of assets gets that information. What do they do with it? Can they go, they say, oh, crap, they have a ton of exposure to this part of the market that we know is in dire straits or is about to collapse. I'm going to go pull my money out before these other investors can. The other investors can stop holding it. So that's why the redeemability is an important consideration, because in order for information rights to have a material negative effect, the investor who's receiving those information rights has to have the ability to act on it in a way that is to the detriment of the other investors who don't have information. So something to keep in mind when you're considering whether something is an information right that would have a material negative effect on investors. And again, I don't want to mean that this is the view that no matter what, if you're in a closed-end fund, you just have a blanket ability to provide information rights. I think needs to be more thought to it than that. But I think this is a helpful piece of the guidance or the adopted for closed-end funds. I think that's the big pieces of material negative effect, and then we'll move on to the next one, which is similar pool of assets. So we've kind of mentioned this a few times in the prior slide. What is a similar pool of assets? So this is important, and you'll see the distinction on the next slide when we move to disclosure. The SEC has drafted the prohibitions broadly and created this term similar pool of assets, which they've actually expanded from the proposed rule, which said substantially similar pool of assets, to now just similar pool of assets, to say that if an information right or redemption right is granted to an investor in one fund, not only do you have to look at whether or not it has a material negative effect on investors in that fund, you also have to look at whether or not you have other similar pool of assets that may have an overlapping investment strategy or investment holdings to the fund in which you granted the information right or the redemption right, such that the investor with that preferential right could exercise its redemption or information rights to the detriment of other investors, not only in that fund, but in another fund. And in the information rights example, if you have, again, provide information on holdings or sectors, exposure, et cetera, where somebody has the ability to use their feet and walk because they have redeemability in that fund, then could not only impact the investors in that fund, but it could in fact impact investors in another fund who may not have redeemability, who may not have the same advanced information rights, but have similar exposures to that investor in that fund. So I think importantly, I think the last takeaway on the prohibitions is I think it's important to kind of, from an implementation perspective, start a scoping exercise, now or at the point in time where we say, okay, I'm less optimistic about the litigation, or if this is going away, and you're kind of really putting pen to paper. When you reach that point in time and are really considering how we're going to implement the rules and create processes to make sure we're complying with the rules, I'd first do a scoping exercise to figure out what pools are similar pools of assets, figure out what pools have redeemability, right? Which ones are all closed-end funds, or if we have multiple open-end funds, or maybe we have closed-end funds that invest alongside open-end funds with overlapping holdings, how those interrelate with respect to their treatment as similar pools of assets. Figure out what redemption rights and information rights have been granted historically. Now, obviously, you have legacy status with respect to previously granted rights, but oftentimes, right, the way we all know these negotiations with investors is like, I got this last time, I want it again. So figure out where your kind of scope of exposure is moving forward with those investors that you previously granted these rights to with respect to future funds and future investments for those investors. And then kind of lastly, start thinking about a process, right? So when these information rights come up and you're talking to your IR teams or your investment teams that are negotiating these rights with investors, and they're saying, hey, we have to give this right, we need to get this money in here, or this is a big investor, that way we have a strategic relationship, we need to give them this right. Okay, how am I going to sit down and go through the process of figuring out, does this create a material negative effect on other investors in this one? What are the similar pool of assets for this one? So I think if you do the scoping exercise, you kind of create a process. You can kind of, in real time, when these things come up, figure out, okay, is this a problem? Is this something that's going to be prohibited? And kind of the helpful part of that on the back end, well, then you have a written record of kind of going through that process, thinking through that. So if you make a determination that something doesn't have a material negative effect, the SEC comes in and asks about it, you have kind of the documentation of the compliance process and the thought was going to this in explaining it or defending why you took the position. Okay, with that, we can move over to the disclosure obligations. We'll cover this one a little bit more quickly, but I think probably spend the most time on pre-commitment disclosures because I think that's getting the most focus and probably is the most impactful on sponsors. So the disclosure obligations fall into three buckets: pre-commitment disclosure, post-commitment disclosure / post fundraising disclosure with respect to closed-end funds, and then third, annual disclosure requirements. Unlike the prohibitions under the preferential treatment rule, the disclosure obligations are not granted legacy status. So if you have a fund that is fundraising at the time of the compliance date or anything to raise after it, even if you held closings before the date of compliance, you now have to comply with the disclosure obligations. So going in turn of the disclosure obligations, first, pre-commitment disclosure. There is a pre-commitment disclosure requirement for what the SEC calls material economic terms. And importantly, on that first bullet point on the slide, reference preferential treatment provided to other investors in the same private fund. So material economic terms is granted to investors in the same private fund. That obviously, as you've seen in the prior slide, and I've talked about for 5 minutes, is different than a similar pool of assets. Now, it's an interesting distinction. I don't know. I wasn't in the room writing this rule, so I don't know how much thought the SEC gave to this and the impact of the distinction. But it is an important distinction in that now the disclosure is limited to investors in the same private fund where the preferential treatment is granted, as opposed to this much broader set of, or potentially broader set of funds that qualify as a similar pool of assets. Now, on that point, I would note it made, from a practical perspective, it may be useful to think about, okay, is same private fund as simple as this exact private fund, or do I have, maybe I have a US taxable fund, maybe I have a tax blocks fund that invest in parallel, a true parallel fund scenario. Do I want to treat those as the same private fund? Will the SEC think of those as the same private fund more so than, okay, I have a closed-end fund and I have another closed-end fund or an open-end fund that may have a somewhat similar strategy or exposure from a portfolio holding perspective, but clearly is different than the same private fund term as used in this section of the rules. So what does a material economic term mean? Again, the SEC didn't define this, as you'll see with a lot of things in this rule, but they did give some examples, which I think are helpful to kind of give context of what they'll think of as a material economic term. One is preferential treatment regarding the cost of investing, regarding liquidity rights, although I don't know how that liquidity rights differs. Maybe it differs from redemption rights in the context that you have some sort of liquidity, but you determine it hasn't risen to the level of material negative effect redemption right that would be prohibited. Fee breaks, obviously, that's the big one. That's the one that most people are focused on, and that is probably the most common in this space. And then fourth, of the list of enumerated examples is co-investment rights, which is interesting to call a material economic term. And I think there's probably some thoughts to what does that mean with respect to co-investment rights? Does that mean I've given people a priority co-invest, or the ability to co-invest in every single deal that I do out of this fund? Or does that mean I told people, hey, yeah, I'll think of you if I have co-invest, which we see a lot in some. So some thought probably given to what does co-investment right mean and what types of co-investment rights or co-invest provisions in a side letter would rise to the level of creating a material economic term. The SEC did say that the next slide, I'm sorry, that material economic terms is the concept, the introduction of that concept is meant to narrow the scope of the disclosures that you have to provide prior to closing on those investors. But I think with the way they define the terms, it may indicate that it's not as clear cut as just fee breaks. The SEC otherwise dismissed timing concerns with respect to potential impediments on closing, and I think we'll talk about this quickly with respect to implementation notes here. But first I wanted to touch on the SEC kind of not offering an approved approach to disclosure of side letters or other agreements with respect to investors that invest in the same closing, or with respect to investors that have invested in a subsequent closing that have received a term that is now more favorable than an investor who has invested in a previous closing, and whether or not that means you have to go back to the investors that invested in close one and tell them what rights you gave to co-investors in close two. I think my view, and I think some view of some in the industry, is that that seems a little preposterous. But I think there are others' views that, in particularly in the closed-end fund context, is, well, should I go back to my fund, close one, close two investors if I've granted close three investor a right that's better than theirs? Does this mean I now have to go back to them, basically tell them about it, and effectively reopen negotiations with them? I think that seems like a bridge too far to me, but we'll see where the SEC comes down on that. But something certainly to think about. So implementation notes on this, I just think it's important to start thinking about the process for how you're going to provide these, particularly pre-commitment disclosures, and whether or not, how many days you're going to give people to see these disclosures. Is it going to be something that's part of your pre-closing package? Is it going to be something that you give people a little bit more time with? Preparing to deal with investors, particularly in the first few rounds of this, once the compliance date comes into play. What types of leverage these LPs are going to have in coming back to you and saying, okay, I got disclosure about all these fee terms that you grant to other people. I know I'm not the same size as them, but can I negotiate for better terms? Right? Thinking about the process for dealing with it, thinking about the process for delivery. Those I think are the things to start thinking about now. I'll cover in 1 minute these next two, so I could take up less time and give others the floor here to finish this out. The other things, post-commitment disclosure on the next slide, is the second bucket of the disclosure rules. Basically says anything that's not a material economic term, you have to provide to investors as soon as reasonably practicable following certain events. One, for a closed-end fund following the final close. So you do that within 4 weeks of the final close. These are things like excuse rights, other non-material economic terms that we granted in side letters. Or for closed-end funds, you have to provide, or excuse me, open-end funds, you have to provide that within 4 weeks of the particular investor's investment in that fund. And then the third prong is annual disclosure requirements. Basically says on an annual basis, you have to provide disclosure of everything you've granted to investors in that fund. In the open-end fund context, where it's not a dormant open-end fund, you're continuing fundraising, this will apply on an annual basis. You probably think about what timing that is. They didn't prescribe any timing, just said on at least on a basis, maybe make that part of your annual reporting package. For closed-end funds, you wouldn't be required to do the annual reporting packages if after the final closing you don't grant new rights. But if there are certain scenarios where you have a transfer or some sort of tender offer or secondary process where you've granted new rights to a new investor, then you trigger an annual disclosure requirements where you have to provide a disclosure package to existing LPs in that closed-end fund. I think that's it. We've talked about the key takeaways, we've talked about implementation. Just one piece on the content. You can do so either via providing an anonymized copy of the side letters, or in the context of providing a written summary of the preferential terms. This is for the disclosure piece. If you're providing a summary, the SEC said that summary can't be too vague. You can't just say we've granted rights with respect to fee breaks. It has to say we've granted a fee break of 50 basis points to, you don't have to tell them who the investors are, but that you've granted it to the X number of investors. So there has to be sufficient detail in the disclosure. And then there's a key takeaway slide. You can look at that at home, but we kind of talked about all those implementation points and key takeaways if we talk through those slides. And with that, I will wrap it up and hand it over to Alba for restricted activities.
Thanks, Nick. Let's jump to slide 28 and we'll make quick work of this, folks. You'll get this deck, and obviously there's a lot more detail here that we're happy to answer on one-offs as you need. But the restricted activities rules is sort of a really good example of where the SEC pared back a little bit. Here, the rule started as a prohibition and adjusted to notice and or consent in various pieces. So on the next slide is sort of a great summary of the 5 different pieces of the restricted activities rule. And many of you may be familiar with sort of components here, but it's worth calling out the first here and the 5th, which is restriction on an advisor charging the fund for governmental or regulatory investigations, and restrictions from borrowing from a fund. Each of those are going to require specific consent from the advisor. This is notwithstanding the fact that your LPA partnership expenses may clearly disclose this as a permissible expense. The SEC is sort of going back on that and saying, good for you, but you still need specificity. And so you will need to get additional consent when there's an actual number assigned to either of these pieces. So really going back on the LPA document and sort of more insult to injury here is the LPAC is not enough. There's a lot of disturbing language in the release about the lack of efficacy of the LPAC because it could be conflicted, and therefore they are requiring you to go to get consent from the LPs. The other three restrictions here are more notice requirements. The advisor charging regulatory compliance or examination fees, that's disclosure within 45 days of the quarter end. You can imagine folding that into your quarterly statement that Melissa walked us through. Similarly for advisors in clawback, if you're in that unfortunate circumstance, you have to disclose certain details about how you're calculating that clawback, and the slides go into more detail there. And then the piece that I think will affect most advisors is number 4, restricting from fees and expenses on a non-pro rata basis and how you allocate those. It's tied specifically to making an investment. So it's worth sort of thinking through what actual expenses does this come into play. If you have upper tier issues or expenses that relate, legal costs for a specific feeder fund, that's not at play. That makes sense that only that feeder fund would bear those costs. This is really tied to the actual investments being made by the fund, for example, broken deal expenses or subline expenses that may not get allocated across your co-investment. So these are scenarios to keep in mind. And if we can just sort of fast forward actually to slide 32, where we talk a little bit about the regulatory compliance and exam fees. I just want to give you a flavor of the types of things that need to be disclosed. Again, this is a disclosure, not a consent piece. But the idea is even if your LPA gives you permission to charge certain expenses, this will require a specific disclosure of amount. So think of things like if you have Form ADV costs pushed down to the fund, Form PF, AIFMD costs, various things that are sort of ordinary course because they're clearly disclosed in your partnership expense definition are now going to fall into this category. So we'll need to make sure that they're getting disclosed specifically. And I'll jump towards the end here of section 30 or slide 38 to give you an idea of just sort of key takeaways. And again, there's a lot of detail in these slides that will get circulated to you. But as far as what should you be doing now, this rule comes into compliance come September. So your first quarterly report will be due basically this year. And it's worth talking to your finance team to maybe go through prior quarterly expenses to get an understanding of what documents or what expenses need to be disclosed here. What have we traditionally expense down to the fund without the second thought of it that might come into play of things that might need to be either disclosed in advance or get consent to. So that's just a good exercise in the background to go. I guess maybe just to highlight one thing on Nick's process of restricted activities, those of you that are in fundraising right now, you're certainly seeing pressure from LPs to talk through some of these issues. I would, as far as where you could be right now, we've certainly worked with clients looking at old side letter compendiums to think through which of these terms would be material economic terms that would need to be disclosed earlier versus what can wait till the end. So as well as thinking through how are we going to meet our disclosure obligations? Would we do the method that Nick is describing of a side letter compendium, just dropping that summary in? Would you do the drop all thousands of pages after redacting the names to make it as useless as possible to the LP? A variety of ways. I don't know that anyone has come to an answer here. I think most clients are just sort of waiting and seeing. With that, let me turn it over to Josh because I think I want him to definitely talk through a couple of the rules, but also there's one sort of, it's not a rule, the liability standard that the SEC snuck in on the release language that actually has effect basically day one.
Yeah, thanks a lot, Alpa. On advisor-led secondary transactions, I think if this had been the only private funds rule, we wouldn't be having a webinar right now. Really a mandate in a transaction where LPs are given a choice to cash a roll, that you get some sort of outside valuation from an independent provider and provide some disclosures to investors prior to the election date. That's where the industry has already gone. So this is largely water under the bridge. SEC originally had said formal fairness opinion would be required in every case. And I know IAA's letter was one of the key points that they used to sort of back away from that and say, okay, other forms of less expensive valuation would be fine for our purposes. So kudos, IAA, on that. Skipping ahead to the next slide, I think we have a little more on secondaries. Again, the details you can review after this session. On slide 41, annual audits. Now, most of you who work at a registered investment advisor are already getting annual audits. A couple of key impacts here. One, this is kind of the death knell of the surprise examination for custody purposes for 3C1s and 3C7s, because an audit is what's now going to be required. And there's some vehicles that it's just hard to audit as a practical matter. That's no longer going to be an option. And the second key implication of requiring audits for every year that a private fund is in existence is late in a fund's life, when you're down to a last couple of assets, you're down to sometimes even just a litigation contingency. Over the years, we've really engineered a lot of solutions to avoid getting an audit under the argument that the advisor no longer had custody. Now that also is going to be foreclosed. So few changes coming to end of life structures. We're actively working on solutions there as well, but just wanted to flag those two key issues. On to slide 42. I think I just talked through those key takeaways. So 43, please. Written annual review. If you weren't doing that before, I don't know what really to offer for you. There was a loophole that the SEC has effectively closed, that you could run an annual review and then never write down a single word about it. As those of you know who have been through an SEC exam in the last 5 or 6 years, they ask for it every time. And so you, as an industry best practice, have had to produce those. Record keeping is, of course, a component of every SEC rule. You have to prove up your compliance with this and produce records on the next exam. On the next slide, 44, is the point that Alpa mentioned. There really wasn't an adopted rule on this topic, but it didn't really inure to the benefit of the industry. The SEC saying in the adopting release that it's inconsistent with a fiduciary duty to indemnify an advisor for breaches of that fiduciary duty. And this really comports with a lot of examination experience in the last couple of years, where depending on your draw from the examiner pool, many of you have already heard of the language that a lot of folks have had in their LPAs for years and years, that indemnification will take place to the maximum extent not permitted by applicable law. The adopting release gives the SEC's view that, well, if it's unclear as to whether investors are being asked to waive their Advisors Act federal fiduciary duty, they sort of view that as impermissible, and an impermissible use of a liability limiting or indemnifying clause. And so Alpa's right. Sort of day one, we've already seen clients, finalizing an LPA, going out with the first draft of LPA in new fundraisers, saying, hey, can we address this in some way? And as a result, seeing slightly stronger language in recent LPAs than we did for years and years. For older funds, we're not seeing a lot of traction to go back and amend unless the SEC shows up on exam and tells you you have to. But I think there's a good opportunity here for registered firms in particular, although also for ERA firms to clarify in some sort of disclosure or otherwise that they won't read those provisions to waive any non-waivable federal fiduciary duties. So trends will certainly continue to evolve there, but that is one that the SEC seems to be accomplishing its goal even without passing the rule as originally proposed. And with that, that concludes the substantive piece. Monique, how about I hand it back over to you?
Great, thank you, Josh, and thank you, Alpa. As a reminder, you'll receive an email with a link to the webinar evaluation later this afternoon. The second CLE code word is strategy. And if you're seeking CLE credit, you'll need to log on to input your code words as proof of attendance. Well, thank you, Alpa, Josh, Melissa, and Nick for an excellent presentation today. Thank you all for joining us. We hope to see you in Washington, D.C. next month at our compliance conference. Have a happy Valentine's Day and a wonderful afternoon. Thanks again.